that I didn't get to know Isabella while making the movie because we met a couple times, but we weren't working together.
Yeah.
And Colleen is really the one who, Colleen connected with me. But Colleen was incredible in saying, like, okay, the book is one thing and the movie also is another thing. And we have to make sure that we're not making a replica of the book if it isn't always the best and most authentic choice for the moment. And I think because of that, it's a very true adaptation of the book. Like, it is very, very, very true to the book. And
Hey besties, things just got really, really, really juicy. Do you remember this whole thing we've been talking about on this channel about Blake Lively versus Baldoni, Wayfarer, and all of these PR people, and how there's this big case that's been the splash of the headlines with a lot of allegations of retaliation, and everyone's all like, "But Blake, I thought you were SH'd on the set. Where did that go?" Well, when she filed her second amended complaint and Jed Wallace filed a motion to dismiss, you might recall that I pointed out that Jed's response was actually a roadmap for Wayfair on how they could also get rid of these claims. At the time, I even questioned why Wayfair didn't just file their own motion to dismiss. It appears that instead they were going to go for what's called a judgment on pleadings. Well, a judgment on pleadings is different than a motion to dismiss, and they have filed one. And this judgment on pleadings could eventually and essentially eviscerate the entire case, leaving this to a basic contract dispute between It Ends With Us LLC and Blakel Inc. and Blake Lively. Everything else would be gone. So a lot of people want to know what a judgment of pleadings is. Basically, what this is it's similar to a motion to dismiss, but instead it's filed after the pleadings closed, meaning after you, the defendant, has responded and filed an answer. It allows the judge to look at the four corners of the complaint and any other pleadings like the answer. Additionally, the attachments or the exhibits that are included in the complaint can also be considered. So if she referenced things like her 17-point agreement, or if she shares exhibits about these documents, those can also be considered. So in the heart of this case, she has brought forth all of these claims that are, again, related to sexual harassment and retaliation, and then these contract disputes. What the judgment on pleadings is asking the court is it's before it goes to a motion for summary judgment, where they actually will look at more details in the discovery. This is the last step before you get to summary judgment. It's not always used, but it's a way for Wayfair to drill down what is actually legally permitted to move forward. It also shores up that if they get a ruling that's negative here, it gives them an access for appeal. So it shows what their disagreements were about her complaint from the very beginning. So it's putting a record on to the judge, like, listen, you can decide to dismiss these claims against him with prejudice, or if you don't, it'll give them grounds for appeal. Okay. And they're making it too clear to the judge with this filing that, hey, this is what we believe and why we believe these claims are not permitted under the law. It is not looking or disputing the facts in the allegations. So it's saying to the judge, listen, if everything else is true, if we take her complaint as truth, this is why this doesn't work. Okay. And they go through this sort of systematically, where they look at the various claims that relate to either the sexual harassment or the retaliation. And they look at from both the state and the federal side. And so when they look at the FEHA claims that are from California, they're going to tell the judge that, listen, this is not a law that you can apply outside of California. And because of that, you should dismiss this. These are only supposed to be applied within California for California residents for actions that occur inside of California. And they detail in this motion about how Blake doesn't meet that burden. The other aspect they tackle is something we've talked about quite a bit, is that she actually fails to allege any adverse employment action. that's required under both FEHA and Title VII, which is her second cause of action. They also claim another area they're going to look at is that she doesn't plead a link between her complaints of harassment and any alleged smear campaign as required under FEHA and Title VII. She doesn't plead temporal proximity between the alleged protected activity and the commencement of the alleged smear campaign or retaliatory purpose. And that part is pretty fascinating when they dive into this because they talk a lot about how she makes this claim in this month, and then all these months later, this is what she says is proof, but she doesn't tell us how. Okay. And then they also say that she fails to allege that she exhausted administrative remedies, which is something I got so much flack for bringing up, and they're bringing this up to the judge. And then the defamation claims they say are barred by privilege, the same thing that he did to the claims for defamation against Wayfarer brought against her. And then she fails to plead a civil conspiracy. So what they do is they do a synopsis of what her allegations are. And if you recall, they sort of paint the picture of how this all broke down. And, they agree in her own complaint that this all happened in New York or in New Jersey. And the very first part of this pleading goes directly to these FEHA claims. Okay. So the motion goes after these claims. These are her second through seventh causes of action, and they cover harassment, retaliation, hostile work environment, failure to prevent, aiding and abetting under California's Fair Employment and Housing Act. They start out by ruling on and asking them with the rule that's on territoriality. And the pleading literally says that California recognizes a presumption that its laws don't apply to conduct outside the state unless the legislature clearly says so. And what they do is they cite a case, which is Sullivan versus Oracle and Ward versus United Airlines for that principle, and they apply it to Blake. So what they say is she's a New York resident. The film was shot in New York and in New Jersey. In her own second amended complaint, she admits that Baldoni and Jamie Heath were in New York during this alleged harassment, and the pleading calls the complaint bereft of any allegations that Steve Sarowitz, another person that she sued, participated in or ratified anything in California. So, an element of the FEHA is basically that someone within the company would have had to have known about the conduct that occurred on the set, and then they had to have condoned it. That means that they did nothing about it, and so they just ratified it. They accepted it. They might have laughed it off. They ignored comments, whatever it was. And what they're saying here is that she's a New York resident. She alleged that it happened in New York and New Jersey, and that the SAC lacks specific averments of any participation in or ratification of the harassing conduct by Wayfarer, or it ends with us movie in California. Translation is that she wasn't and hasn't alleged that her actual employer or anyone in California with authority knew about and approved the misconduct. Without that, she can't meet the ratification element under the FEHA. It basically means they approved it, they adopted it, and they let it stand. So she's saying they didn't do anything, they ratified it, they allowed this to keep going on, and she can't even tie it back to them doing anything in California. And because of the way that the law is set up in California, her complaint would have to tie it back directly to California. Okay. And so the motion is essentially emphasizing that everything happened in New York and New Jersey, and that her own complaint admits that Baldoni and Heath were in New York when this occurred or in New Jersey. And that even though Steve's also on this Wayfarer, he's not even there too because he's in Illinois. So not only did harassment not happen in California, none of the decision makers she blames were in California either. And so that's why it's saying that there's no extraterritorial application. That's a hard word, and I'm going to just let you hear me try to pronounce that. Plaintiff's FHA claims are not enforceable. That's what she's telling the courts. Then the next part is basically going directly to, well, even if you were to take them as they are applicable. So, assuming that you can apply them outside of the state of California. Blake failed to exhaust her administrative options, which is required under both Title VII and FEHA before you can file a lawsuit. And that because of the way that she filed her CRD, she never included her actual employer of It Ends With Us, LLC, as in the CRD. And what's extremely interesting is that in the case that's Lively versus Wayfair, Blake has moved to seal the actual CRD complaint that she has already put out to the New York Times. She wants it sealed so you and I cannot see the letter for her right to sue or who was named. But the thing is it's already been put out into the public. So we know based on what was published and what Jed Wallace has attached in his own claim against her in Texas, she did not include It Ends With Us, LLC. She said Wayfair Studios is an employer. And she included Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and then these PR agents like the TAG groups, the Jennifer Abels group, and Jed Wallace's group. There are problems with that alone because PR agents are not her employer. And under this, she specifically doesn't even suggest that there was a retaliatory act that occurred, which they're going to get into as well. The actual retaliatory occurrences have to meet a specific window. But what they're saying is that because she did not file a complaint with the California Civil Rights Department against It Ends With Us, she never received a right to sue It Ends With Us, LLC. She filed it against 10 defendants who I just named. It Ends With Us movie was her employer and the party to her actor's loan out agreement and the writer. It is not identified in her CRD complaint, and she did not obtain a right to sue. And they also say that accordingly, it's entitled to a dismissal of the third, fourth, sixth, and seventh causes of action. In addition, as more than 300 days have elapsed since the allegedly unlawful employment practice, and It Ends With Us movie is entitled to dismissal of prejudice of her first and second causes of action. So under the law, if you're going to sue for employment discrimination, you have to include who your actual employer was in order to bring a claim of FEHA. And when she signed her agreement and that 17-point agreement, the writer, if you notice the signature line, it doesn't say it's between Wayfair Studios, and her signed her attached copy in this complaint itself also states that the agreement is between It Ends With Us movie LLC and Blakely Inc., not Wayfair Studios and Blake. Wayfair Studios is the studio that helps fund it, but the movie itself is its own business, and you can't pierce the two for employment because she'll say, well, they just work both. She's trying to blur the line and say, well, they work at Wayfair and they work at It Ends With Us. But using its own business to make a movie is super common because it protects the studios from liability. And then all the payment and all of the taxes and all of the records go through It Ends With Us LLC. So it's its own separate business specifically for a movie. And that was her employer. So what they're doing is taking two separate approaches. The approach for Wayfair is that you have to dismiss this because of you can't apply this outside of the state of California to get rid of all of those FHA claims. And then for It Ends With Us, they're saying you can't even move forward with these because of the law. And she didn't exhaust it. And she never named us with the FEHA. So it's two separate approaches, but it's aiming at getting rid of basically the same counts against the two separate quote unquote employers. Much like a motion to dismiss will take different angles for an argument of what a judge can decide. The judge could decide on any one of these or disagree on any one of these. And so they're giving as many reasons to the judge as to why this isn't valid. And the other aspect here that they also tackle is that she doesn't plead that there was an adverse employment action within what's required under the law for both FEHA and Title VII. And here's the really difficult part about sexual harassment in labor discrimination cases is that if you can't prove that a retaliatory act happened, proving sexual harassment alone is extremely hard to win in court. There almost always needs to be an element of retaliation to succeed. And so essentially, if they hammer at the retaliation being there's none, thus she's going to have an uphill battle to try to prove the sexual harassment. So, in order for her to properly plead retaliation, she has to show that she engaged in a protected activity, that the employer was aware of the activity, and that the employer took an materially adverse employment action against her, and that this causal connection existed between the adverse employment action and the protected activity. And within this, she doesn't, they're saying, and that she also attempts to blur the line between Wayfarer and It Ends With Us movie, who is the party to her loan out agreement, and her employer. And Wayfarer is not a party to the loan out agreement for Lively's acting services or the writer. So this is again where they are saying Wayfarer is not actually technically her employer. So it's another way of sort of asserting that the real employer here is It Ends With Us, and that there was actually no adverse action taken against her. And they go as far to say is that she does not allege that she was terminated, demoted, deprived of any benefit of her employment with It Ends With Us movie, assert any act that any have blocked or interfered with a potential employment opportunity, or other any material adverse change to the terms of her employment. It includes only 3 references to an adverse employment action, each alleging a coordinated campaign to cast her in a false light during publicity and promotion of the film. Her claim of adverse employment action is based solely on the publication of negative publicity commencing in August of 24, after production ended and after discord on the set had spilled into the public eye. No adverse employment action where a plaintiff was no longer an employee, worked at a different job, and the defendants lacked control over any aspect of their working conditions. And I want to make abundantly clear that Blake Lively is moving and demanding that the court seal the complaint that is literally public on a link to the New York Times. She is saying that the CRD complaint is confidential and must be filed under seal. And so because of that, they have to black out what is in this complaint that's already been made public. But to Lyman, she's telling Lyman it's confidential. And in this, it cites from page 62 of the complaint that you can literally find on the web link for the New York Times. Miss Lively's discovery of the full extent of the retaliatory campaign launched by the Wayfarers has left her with no choice. Through this complaint, Miss Lively seeks to set the record straight, to hold the Wayfair parties and associates accountable, and to shine a light on this new form of retaliation so it will no longer be used against any others who seek to stand up or speak out against sexual harassment. So she acknowledged in her CRD complaint that she's now trying to hide the Lyman, that we can already see that retaliation, if she were to make this, that the state would have to apply a new form of retaliation, not what's already allowed, a new form. That's how bananas this is. And it's even more bananas that she's hiding this under the seal of confidentiality. I mean, that alone even would make it so appealable for Wayfair to say, see, judge, she says this is confidential, and yet this is what the New York Times reported on. Blake says this is confidential, and yet this is the grounds of the entire New York Times article against us. So basically, what they're saying is that by creating a new standard for adverse employment action, she fails to allege any action of adverse employment occurred against her. It's like they systematically just keep drilling down how poorly pled these FEHA claims are. So then they're saying even if a smear campaign is a retaliatory act, even if, judge, she can't even connect this alleged smear campaign to her protected activity. They say there's no causal link, and that's a required aspect and factor when you plead retaliation. It has to be that the employer's knowledge that the employee engaged in a protected activity, and then the proximity in time between the protected actions and the employment decision. a retaliatory purpose to be shown directly or indirectly by timing. And then this is where they talk about she first makes her complaint according to her own SAC in May of 23. And then August of 24 is apparently when she says they retaliate, which again is 15 months after, 15 months later. And then they give a whole bunch of case law about how that's way too far away. 10 months can even be considered too far away. 7 months can be even too far away. And if she surfaced her grievances in May, and then this campaign begins in August, 15 months later, and then even if they go to January 4th as the last, as our all hands meeting, where she claims she renewed her complaints, and that's the starting point, that's again a 7-month gap. And that she would have to, she didn't prove that that 7-month gap is the reason why he hired PR. The crisis management public relations campaign designed to counter the already negative and escalating publicity spurred by Lively would have occurred and did occur in the absence of a retaliatory motive. And this is where they go at that this, hiring these PR people was somehow retaliatory and done because of her protected activity. And they're saying she doesn't even have a retaliatory motive here. In fact, the SAC's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Wayfarer and Baldoni against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to coincide with the film's release. She cites text messages to support her claim of retaliation, but they do not evidence a retaliatory purpose. To the contrary, they confirm that in late July of 24, after completion of production and at the end of her acting services, Baldoni and other Wayfarer parties consulted a PR team and crisis management on how to counter an anticipated onslaught of negative publicity by Lively about a feud on the set of It Ends With Us movie and struggle over control of the production, editing, and marketing of the film. We should have a plan if she does the same when the movie comes out. Would be helpful to arm us in the case we need to refute any claims. Armed and ready to take the story of Blake weaponizing feminism. Scenario plannings should give Lively and her team to make a grievance public. Even going to the heart of those reckless thoughts of wanting to plant pieces this week of how terrible Blake is to work with, just to get ahead of what she's already put out, basically. They even tackle at going back and forth with any negative accounts, helping to change the narrative and stay on track. Abel inquiring about the cost of social media mitigation and proactive fan posting to counter the narrative. The defendant's concerns proved prescient when, on the eve of August 6th of the premiere, she sidelined Baldoni, instructed cast and crew members to defriend him on social media, and refused to be seen or photographed with Baldoni at the premiere, where Baldoni and his family were banished to the basement until she finished her pre-show appearances. The public fervor over Baldoni's distress over efforts to cancel him and Wayfarer's goal to flip the narrative and repair his reputation are reflected in the text messages. So this is all about protecting them because of what she had done with the premiere. And that's really where all of this came from, what happened at the premiere. That's when stuff on Reddit starts coming out about competing film cuts, and that, Nathan says that Lively had fucked herself by doing the unfollow thing, insisting on no photos together. And so they say what Lively categorizes as a smear campaign began the week of the premiere and was conceived and executed to counter the onslaught of negative press spawned by Lively and her team, quell speculation about the alleged rift between Baldoni and his cast and crew, and explain Baldoni's noticeable absence from joint press events and the lack of group photos at the premiere. She, in fact, admits the plan was not conceived in response to any particular allegation. It was entirely about managing the public perception that Baldoni feared might follow the theoretical possibility that Miss Lively might decide to unfollow his social media accounts. Planning to counter potentially negative publicity and efforts to defend one's reputation in face of highly public criticism is not tantamount to retaliatory adverse employment action. She fails to plausibly plead the requisite causal link between her protected activity and this PR campaign. And they end it by saying, Lively may not like the public criticism she unleashed, but the SEC is devoid of facts that might show that these efforts to neutralize negative publicity had retaliatory purposes. Absent a sufficient factual basis, the FAC's conclusory allegations of retaliation fail to establish a prima facie showing that the sexual harassment complaint were or but the cause of the smear campaign, and it's required to plead under Title 7 in FEHA. And that's such a good way to end the FHA stuff. Now, the stuff about defamation isn't really necessary to go into too deeply because the defamation claims that she's bringing up are all sort of from out of court statements that were made by Mr. Friedman, the counsel for the defendants. And because of that, they're basically just saying that, you know what? This is all protected under litigation, and it's the same thing. It's litigation privilege, and you can't, they're afforded absolute privilege the same way Blake was when she made her CRD complaint public, right? They're saying the same applies. And there's no invasion of privacy under New York law. So there's no grounds really for the defamation claim. So I'm not really going to get into it. And then the final is civil conspiracy. And according to her claim, it can't stand on its own because under California and New York law, it's not an independent tort. It only extends liability when there's a valid underlying tort. And the motion argues that Lively hasn't pled a viable underlying tort that could support a conspiracy because FEHA claims and Title 7 retaliation and defamation theories all fail on their grounds. And without a surviving tort, the conspiracy count collapses automatically. So it requires that the alleged co-conspirators were legally capable of committing an underlying tort owed a duty to Lively. The underlying claim is barred. And if it is barred, then there's nothing left to conspire about. And the court is urged to dismiss it because it can't create a free new standing liability category. So what this is asking the judge to get rid of are essentially the first cause of action, dismissing It Ends With Us movie, the 2nd through 7th entirely against everyone, the 12th through 15th entirely, and civil conspiracy, okay? And what would be left would be 1 count of Title 7 under Wayfarer, and then 2 breaches of contract for her loan out agreement and for her that rider that she signed, the provision of no retaliation that's within that rider. So what the case ends up becoming is no longer about employment discrimination, but a dispute between a studio and their client about a breach of contract. Quite different. And they'll be able to defend themselves much easier under that. So I believe that this actually has teeth. There's a lot here that will make it very hard for her to respond and to argue. Now, she'll try, she will, but the judge already granted a motion to dismiss for Wallace. And even though he didn't look at the merits of the stated claims, he pointed out there was weakness. And when you have to go by the law. And if you don't meet the requirements for a pleading under the law, it has to be dismissed. And so if it's denied by the judge, they can appeal that. And it's also, again, a marked record of what they believe is wrong with her pleadings. And then if it's approved, that means only 2 grounds move forward. And this whole BS about a smear campaign just basically goes away. It doesn't even exist anymore. And it's all just about you breached a contract because you talked about me publicly. And that's it. But he never said anything negative about her. And she could easily have breached the contract as well. And the most important is that because Blake didn't include a copy of her actual loan out agreement, Wayfair filed one under seal. And what they told the court is that neither party has provided a copy of the signed loan out agreement. So they provided an unsigned copy of the loan out agreement, meaning Blake Lively never signed her contract, which is why she never included that when she filed her lawsuit, because it begs the question is if you don't have a signed contract, what grounds do you have to sue? There's a lot here for the judge to consider, and she's got a lot to fight against. And I think anyone suggesting that this is automatically going to be denied, I think is really getting lost in the fact that the judge has made decisions on discovery. Discovery decisions have nothing to do with the facts or the allegations in the case. It has to do with the rules of discovery. Okay. Rules of discovery are the court rules. It has nothing to do with the facts of this case. Here, they're asking to make facts on the law. And he's already made clear that he's going to follow the law. And that's why he dismissed parts of Wayfair's case. And here, he could do the exact same thing to her case because her pleadings also are, I would say, arguably more defective than what Wayfair presented to the court. This is a big move, and I'm impressed, honestly. And I think that this is a really good step for them. And then next step would be is if they get everything knocked out, then the next would be summary judgment where they can present even more facts about why Blake's case is meaningless and baseless. And trust, even if they get this part denied, they also can move for the same dismissals in their summary judgment. So this isn't the end, but it could really dismiss her whole case. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and please click the bell so you never miss a video. Thanks so much for watching. Bye, besties.